Welcome to This Explainer. We've got a highly critical policy briefing on deck today. We're going to unpack these sweeping amendments just introduced in Ghana's National Identity Register Regulations 2026. That's LI 2523 for those tracking the statutes. Look, whether you're a corporate executive, a business owner, or just an everyday citizen, this legal instrument fundamentally rewrites the rules of identity verification in Ghana. We are officially moving away from paper and visual checks straight into a strictly regulated biometric era.
Let's dive into Section 1, the new regulatory reality. Now, if you take a look at this timeline, you'll see the grace period is officially over. The regulations were gazetted in March 2026 and entered into force by June. What does that mean for you right now? It means active enforcement is already underway across the country as of August. And in the eyes of the law, ignorance of this rapid rollout is absolutely not a valid defense. So what exactly changed here? Well, Regulation 7 of LI 2111 got a complete overhaul. If your organization offers any service requiring an ID, the new law legally mandates that every single identity verification must now be authenticated biometrically against the National Identity Database, and it has to be done using a secured link. This literally closes the door once and for all on those legacy methods of ID checking.
Moving right along to Section 2, Mandates for Organizations.
Now, Regulation 9, Sub-Regulation 2, introduces what is essentially an unbreakable three-step statutory protocol for identity verification. Step 1. You view the information on the National Identity Card or database. Step 2. You absolutely must capture a live biometric. That means scanning the individual's fingerprint or taking a live picture right then and there. And Step 3. You have to securely match that scanned template against the storage on the card itself or the National Identity Database. You cannot skip or alter a single one of these steps. Doing so is a direct violation of the law. Now, here's a really fascinating compliance mechanism introduced in these regulations. It's called match-on card verification. Explicitly defined in Regulation 9A, Sub-Regulation 5, this is a highly secure, entirely offline process. Basically, the biometric comparison happens entirely within the secure integrated circuit embedded directly inside the physical ID card. The real game changer here for data privacy, the individual's biometric reference data never actually leaves the physical card. It's a highly secure, offline verification method specifically approved by the authority.
Next up, Section 3, Prohibited Verification Practices.
Think about that filing cabinet in your office full of photocopied IDs. Under this new framework, that is now a massive legal liability. Relying on a simple visual check or holding onto paper records is officially illegal. As you can see, those practices are completely out, entirely replaced by mandated procedures like match-on-card tech and authority-approved biometric devices.
Let's be incredibly specific here, because Regulation 9A, Sub-Regulation 2 uses absolute, non-negotiable language. Organizations shall not rely on visual inspection of the card. You shall not request, rely on, or reproduce a photocopy. You shall not scan or capture an image of the identity card itself. And you can't just buy some random off-the-shelf scanner either. You shall not employ any biometric method that isn't explicitly approved by the authority. If you don't update your standard operating procedures away from photocopies right away, you're exposing your organization to immense liability. Let's shift gears to Section 4, Rules for Private Transactions.
Now, here is a really surprising fact. These rules don't just apply to big banks or telecom giants. If you're a private citizen verifying someone's identity, say you're a landlord doing a private lease, strict data privacy limits apply to you too. You cannot retain a photocopy, scan, or image of their card. Any personal data obtained from that card cannot be recorded, stored, or shared unless it's legally permitted or you have explicit consent. Furthermore, under the amended Regulation 9, Sub-Regulation 3, it is now an actual offense to refuse to surrender your card to a law enforcement officer or authorized person for a live biometric scan without a reasonable excuse.
Okay, let's look at the consequences in Section 5, Offenses and Penalties.
The penalty structures codified here are uniquely severe. For a corporate body, a contravention of these verification rules brings a hefty summary conviction fine ranging from 500 to 2,000 penalty units. But take a close look at the risk for partnerships. A fine of 200 to 1,000 penalty units is payable by each individual partner. That multiplier effect is a staggering financial risk. And for everyday citizens, retaining unauthorized data or photocopies brings heavy fines of 50 to 500 penalty units. And simply refusing to surrender your card for a law enforcement scan can lead to 50 to 100 penalty units, or even worse, 2 to 6 months in actual prison.
But honestly, the summary conviction fines are just the beginning for businesses. Regulation 9A, Subregulation 4, grants the authority the power to impose administrative sanctions that can completely paralyze a business. They can outright suspend or terminate your organization's access to the identity verification services platform, which effectively halts your ability to onboard any new customers. They can also hit you with a surcharge of up to 20% of your annual verification service fees if you've been integrated for over a year. And if your institution hasn't integrated properly at all, you're looking at a massive flat surcharge of 2,000 to 2,500 penalty units.
Finally, we arrive at Section 6, Regulatory Intelligence and Tracking.
To track these kinds of rapid shifts, deeply understand the policy landscape, and ensure your operations remain strictly compliant with Ghanaian law, utilizing regulatory intelligence platforms like Nexus Tech Policy Advisors is absolutely essential. You can check them out at www.ntpai.nexustechpolicyadvisors.com. So I'll leave you with this final thought. In an era where paper trails are now a legal liability and live biometrics are the only key, is your organization fully prepared to abandon the photocopy, or are you currently operating on borrowed time? Thanks so much for joining this explainer.
Welcome to the highly anticipated next chapter in our data protection series. Today, we're bringing you a brand new explainer focused on an incredibly timely topic, Kenya's newly proposed regulatory drafts for modern technology. Listen, if you're operating in the tech space, if you're building algorithms, or handling any kind of data in Kenya right now, the landscape is about to shift significantly. And this explainer? Well, it's designed to give you the exact framework you need to make sense of it all. Okay, let's dive into this. A recent Dear Stakeholders letter issued by the Compliance Directorate of the Office of the Data Protection Commissioner, the ODPC, is officially laying the groundwork for how personal data must be handled across three incredibly disruptive technological frontiers. Make no mistake, this isn't just some minor update. This is a major, game-changing regulatory milestone. So here's our roadmap for this explainer. First, we'll look at the ODPC's draft guidance. Then, governing artificial intelligence. Third, regulating emerging technologies. Fourth, privacy-enhancing technologies. And finally, next steps for stakeholders. Starting right off with Section 1, the ODPC's draft guidance, and how it's building on the existing foundation. Now, it's really important to remember that these new draft notes do not replace the existing Data Protection Act. Actually, they build directly upon its foundation to address the really unique complexities of modern tech. The guidance is divided into these three distinct pillars you see, and honestly, the timing here is no coincidence. Kenya is undergoing a rapid digital transformation, heavily driven by the government's bottom-up economic transformation agenda and its whole digital superhighway initiative. As this digital landscape expands exponentially, the sheer volume of personal data being fed into algorithms and cloud systems absolutely requires a much more robust, specific data protection mechanism. And the regulatory authority driving all of this is, of course, the ODPC. By mandate, they are uniquely positioned right at that intersection of innovation and privacy. And it's crucial to note, their goal isn't to stifle innovation. In fact, it's to ensure Kenya remains at the absolute cutting edge of digital transformation, but with stringent safeguards that actually protect the privacy and fundamental rights of its citizens. They're essentially the gatekeepers, making sure this digital superhighway is safe for everyone. All right, moving on to Section 2, governing artificial intelligence, specifically looking at developers versus deployers. You know, AI is increasingly everywhere in Kenya right now, from banks running credit scoring models to hospitals utilizing diagnostic imaging. Because of this, the guidance makes crucial distinctions about exactly where you fall in the AI ecosystem. So the crucial point is understanding exactly whether you are a developer or a deployer. If you're an AI developer, your focus is on designing, building, and training the models. But if you're an AI deployer, meaning you simply use an AI system in your daily business operations to make decisions that affect data subjects, you have an entirely different but equally heavy set of compliance burdens. You can't just point the finger at the developer if the AI you're using violates a Kenyan citizen's privacy rights. The ODPC clearly categorizes specific applications as high-risk AI. If your AI touches credit scoring, health diagnostics, student assessments, or recruitment, a Data Protection Impact Assessment, or DPI, is absolutely mandatory before you deploy, period. For example, if a Kenyan university wants to use an AI platform to track student performance and adapt learning profiles, or say a hospital uses it for diagnostics, the risks of bias or data exposure are so incredibly high that a documented DPIA is legally required. Which naturally leads us to a massive question, right at the heart of this draft guidance. Can an AI make decisions about human beings entirely on its own? This is what regulators are calling automated decision-making, or ADM. And the emphatic answer from the ODPC, no way. Humans cannot be left completely at the mercy of algorithms. The guidance clearly states that data subjects have the fundamental right to request a qualified human review of automated decisions. The source gives a perfect example of this. If a public hospital uses an AI system to prioritize patients for specialized treatment, and someone is automatically deferred as low priority, well, that patient must be informed that an AI made the decision, and they must have the right to have a real human doctor review that outcome. Okay, Section 3, regulating emerging technologies and ubiquitous data collection. Because AI is just one piece of the puzzle, right? We also have to look at the hardware and infrastructure that enables continuous and often entirely invisible data collection. The regulatory net cast by this new guidance is vast. We're talking the Internet of Things, cloud computing, blockchain, biometric systems like the Maishanamba, connected vehicles, and drones. Let's look at a real-world scenario from the guidance. Imagine a company called Shamba Smart, deploying drone imagery, soil sensors, and weather stations across smallholder farms in the Rift Valley. That drone might incidentally capture images of farm workers. Under these rules, Shamba Smart must identify a lawful basis for this, provide privacy notices to the workers, and implement data minimization, like, say, deliberately blurring the faces of those workers in the drone imagery. But here's where we hit a really fascinating regulatory collision. Think about blockchain for a second. The whole point of blockchain is that it's immutable, right? The records literally cannot be altered or deleted. But under the Kenyan Data Protection Act, a citizen has a fundamental right to erasure. So how exactly do you delete something from a system that is fundamentally designed to be undeletable? And this brilliantly illustrates the practical nature of these guidance notes. The ODPC actually offers a technical workaround, cryptographic deletion. If technical erasure of on-chain data is impossible, entities can simply destroy the encryption keys. This renders the personal data functionally inaccessible. So you aren't breaking the blockchain, but you are satisfying the spirit of the law by making sure the data can never be read or used again. It's a clever fix. Which brings us to Section 4, Privacy-Enhancing Technologies, the bridge to compliance. So you're probably wondering, how do businesses actually achieve all this technical compliance without grinding their operations to a complete halt? Well, you can think of privacy-enhancing technologies, or PETs, as the ultimate how-to toolkit for businesses that want to innovate safely in Kenya. These are advanced technical tools that let you extract value, collaborate, and run analytics on data without ever exposing the raw underlying personal information. They are the essential bridge between aggressive digital innovation and strict legal compliance. The guidance actually breaks these down by sector. For instance, in telecommunications, companies can use something called differential privacy to share network analytics without exposing individual user activity. In healthcare, it's all about the pseudonymization of patient records for clinical research. But let's look closely at financial services. Imagine a Kenyan retail chain and a commercial bank want to collaborate to see just how effective a joint loyalty program is. Neither of them wants to hand over their raw customer data. But by using a data clean room, they can securely combine the data, compute aggregate analytics, and only release high-level insights without either party ever seeing the other's individual customer records. It's a massive win for both business strategy and privacy. Finally, Section 5, next steps for stakeholders and the compliance checklist. Okay, we've covered the rules and the tools. What exactly do you need to do right now to align with these proposed frameworks? Let's move to and see how this builds into an immediate, actionable compliance checklist. First, if you're deploying AI or emerging tech that processes personal data in Kenya, you must register as a data controller or processor with the ODPC. Second, your privacy notices need immediate updating to plainly explain your use of AI and automated decision-making to users. Third, you've got to conduct those data protection impact assessments for high-risk processing. And fourth, if your core activities involve large-scale monitoring or processing highly sensitive data, designating a data protection officer is a critical necessity. And finally, we arrive at the absolute most urgent takeaway today. Remember, these are currently draft guidance notes, which means your voice can still shape the final regulations. The ODPC is actively calling for stakeholders to submit their comments to compliance@odpc.go.ke by the hard deadline of August 17, 2026. This is a defining moment for Kenya's digital superhighway. Will the industry embrace these privacy-enhancing toolkits, or will the friction between rapid innovation and strict regulations slow the pace of progress? The rules of tomorrow are literally being written today. Make sure you're part of the conversation.